Welcome everyone to the third Be Accurate webinar on post-crediting period guidance and permanence obligations webinar. My name is Dean Smelders, acting as the General Manager of the Soil Emissions Avoidance and Contracts Branch at the Clean Energy Regulator, and I'll be facilitating today's session. This marks our third online instalment of the Be Accurate webinar series, supplementing the in-person workshop held in Canberra earlier this year. I'd like to express my appreciation to all participants for their engagement and attendance so far. These sessions have served as a valuable platform for communicating key aspects of managing the complexities inherent in the ACCU scheme and to support participants fulfil their obligations and meet reporting requirements under the CFI Act accurately and compliantly. If you want to review any of our previous webinars or the material that's arisen from them, you can view them on our website and on the CER's YouTube channel. To begin today's webinar, I'd like to acknowledge the Ngunnawal people as the traditional custodians of the land that we are meeting on, and recognise any other people or families with connections to the land of the ACT and region. I respect their ongoing culture and valuable contributions to our city and region. I would also like to acknowledge and welcome any other Aboriginal and Torres Strait Islander people who may be attending today's event. And in light of the ACCU scheme's objectives, I also recognise the important role that traditional knowledge and stewardship play in advancing sustainable land management and supporting our shared climate goals. As I said today, our session focuses on permanence obligations. In addition to being additional and genuine, permanence is an important component of sequestration methods to ensure carbon abatement over the long term. Today's webinar will outline some of the key requirements supporting permanence in the ACCU scheme legislation. We have several presenters today. Firstly, Gabrielle Meiklejohn, who's from our Scheme Implementation and Insights team, who's going to tell us about permanence plans, monitoring and notification requirements, relinquishments and natural disturbances. Shakir Rose is part of our Plantings and Plantations section, who's going to talk to us about post-crediting period reporting requirements. And Rizwan Akhund and Alyssa Setil, who are part of our legal services team, and they will be talking to us selling or buying property and estate management. The webinar will run for about an hour and a half, about 45 minutes of presentations and another 45 minutes for questions and answers. The webinar is being recorded and it will be published on our website in the coming weeks. During the webinar, your microphones and video feeds will be turned off, but we encourage you to ask questions during the webinar. You can do this via the Q&A feature, which should be at the top of your screen. Please ensure your questions are respectful to the moderators and all of our participants. We recommend not asking private or business sensitive questions during the webinar. Instead, you can always contact us at the CER and we're happy to help. So with that, I will now hand over to our first presenter, Gabrielle Meiklejohn. Thank you.
Lovely. Thank you, Dean, for your kind introduction. I'd also like to acknowledge that I'm presenting today on the lands of the Ngunnawal and Ngambri people, and further acknowledge that Indigenous peoples have been caring for country on this continent for over 65,000 years. I'm Gabrielle Meiklejohn, a policy officer working on the ACCU scheme. I'll be speaking today about permanence and permanence plans, monitoring and notification requirements, and finish by discussing natural disturbances and relinquishments. Permanence is a crucial principle for ACCU scheme projects which draw atmospheric carbon dioxide into a carbon sink, such as soil or vegetation. And these types of projects are referred to as sequestration projects. Permanence requirements aim to ensure that stored carbon is not released back into the atmosphere or otherwise lost. Project proponents must select a permanence period for the carbon that's stored through their project. Selecting a shorter permanence period may mean that the project will receive fewer ACCUs than if a longer permanence period was selected. Discounts also play a meaningful role in ensuring ACCU issuance against projects is conservative and in alignment with the OIS. Monitoring and notification requirements also contribute to supporting project permanence. While the specific requirements differ between methods, proponents have a general obligation to monitor their projects for events which may result in a reversal of stored carbon, and also generally required to notify us of those events. I'll speak more to the monitoring and notification requirements a little later on. Under the permanence arrangements for the scheme, every sequestration project has a project permanence period, which is the period for which the proponent agrees to ensure that the carbon sequestered through the project remains stored in the project area. Proponents must nominate a permanence period, which is either 25 or 100 years. Selection of a 25-year permanence period will generally mean that the project is subject to a 20% reduction in the number of ACCUs issued, though there are some method-based exceptions to this rule. Selection of a 100-year permanence period will mean that the project is not subject to that 20% discount. Carbon sequestration is generally considered permanent if the carbon is stored for a period of at least 100 years, and this was the original policy design under the scheme. The option for proponents to adopt a 25-year permanence period was introduced in 2014 to reduce barriers to scheme participation, and the 20% discount aims to manage risk relating to the shorter permanence of that sequestered carbon. The permanence period for a project is nominated by the proponent in their application for declaration of the project and cannot be changed once the project has been declared by the regulator. The government is considering the possibility of allowing projects to vary their permanence period from 25 to 100 years in response to the 2023 CCA review of the ACCU scheme, though no final decision has yet been made on that. The duration of the nominated permanence period impacts the duration of the obligations that the proponent is under. Monitoring and notification requirements generally extend to the end of the permanence period, and the regulator may issue a requirement to relinquish ACCUs to a proponent through until the end of that permanence period. Permanence obligations exist for the duration of the permanence obligation period, which is defined as the period from the date the project was declared until the last day the regulator could issue a notice to relinquish ACCUs. The permanence obligation period concludes at the end of the permanence period for the project, which again is either 25 or 100 years. As the commencement of the permanence period is the latest of the first issuance of ACCUs to the project, or an approved variation to add area to the project, the permanence obligation period is also variable. In an extreme example, a project may be declared at the start of year 0, be subject to a variation to add area at the commencement of year 24, with the 25-year permanence period then concluding at the start of year 49. In that example, the proponent selected a 25-year permanence period, but was subject to permanence obligations for a period of 49 years. To demonstrate active engagement with and consideration of the permanence obligations, proponents must undertake permanence planning. Proponents are required to outline the steps they'll take to ensure that the sequestered carbon remains in the project area, and to demonstrate they're managing all risks which may result in a reversal of those carbon stocks. Proponents must also provide us with plans that meet those requirements at set intervals, including with the application for declaration of the project, and with the first offsets report after the 8th and 24th year of the project's crediting period. Permanence plans are used by proponents to demonstrate they are actively managing the risks facing carbon sequestered through their project. The specific requirements for permanence plans will differ between project types and within methods, as different projects will have varying levels of exposure to risk. As an example, fire is likely to be a greater risk for vegetation projects than tidal inundation projects, and flooding is more likely to be a greater risk for soil carbon projects than established vegetation projects. Proponents should consider the specific risks that the project may face over the permanence obligation period, and this should be informed by a combination of site-specific knowledge, such as soil type, contours, and vegetation load, regional considerations, such as rainfall patterns, bushfire incidents, and location of floodplains, and risks over a greater geographical and temporal span, such as risks of more extreme weather events and rises in average temperatures that are associated with climate change. Permanence plans should demonstrate that a proponent is actively assessing, monitoring, treating, and responding to project risks. While the plan is only required to be provided to us at 3 set intervals, proponents should ensure it is kept up to date and that it reflects the full extent of risk management relating to project permanence. In the event of a significant reversal of project carbon stocks, the level of planning and mitigation that the proponent had undertaken may affect whether a relinquishment of ACCUs is required. There's no set structure or form for permanence plans. Some proponents opt to conduct and provide a detailed and thorough risk assessment, and others will simply choose to outline the main risks that the project may face and list mitigating measures. The acceptable standards for permanence plans will differ between methods and the specific details of the project, such as location and size. Proponents should ensure that they have assessed and treated all risk to the greatest extent possible, and that the risk planning and treatment is documented in the permanence plan. To support projects under the Environmental Plantings pilot in meeting their obligations for permanence planning, the regulator developed a permanence plan template. The template provides simple information about permanence planning requirements, prompts proponents to consider a number of risks that might be relevant to their project, and suggests mitigating steps that the proponent may wish to implement. Also provided in the template is a section for proponents to record the actions they've taken to manage the risks to permanence. The template is available on our website and has been recently updated. I'll now speak to monitoring and notification requirements for projects. These requirements support the proper operation of the scheme by requiring proponents to actively monitor their projects and report significant events or changes to us. Monitoring requirements are specified in the method applicable to a project and cover a number of varied matters, including compliance with the method, inputs to method equations, disturbance events, and changes in management actions. While the proponent may engage an agent or other party to conduct those monitoring activities, the responsibility to comply with the requirements still rests with the project proponent. Depending on the method, monitoring requirements may specify the technique or technology used to monitor the project, with some requirements allowing for the use of aerial imagery and remote sensing, and others requiring on-ground data collection. Methods may also require that the proponent create and maintain records that evidence the monitoring activities that were undertaken. Shakir will speak to record-keeping requirements a little later in this webinar. While there are other controls in place to ensure projects are in compliance with the relevant method, monitoring requirements place an obligation on proponents to be stewards of their project and to monitor the project for changes that might affect project operation and compliance. Monitoring should be undertaken by people who have the necessary knowledge and skills, such as education, training, or prior experience. The person undertaking the monitoring should also have sufficient experience in and knowledge of the area being monitored, which may assist them in detecting and reporting on changes to the project area over extended time periods. Monitoring requirements and the associated record-keeping requirements ensure that proponents develop a strong evidence base, which can later be used to support reporting for and auditing of the project. These records can help to demonstrate that the proponent is actively managing their project, controlling risk, and delivering optimal climate and environmental outcomes. I'll turn now to the notification requirements part of this webinar. Proponents are required to notify us of certain events affecting their project, with these requirements included across all levels of scheme legislation. As an example, the CFI Act requires that proponents notify the regulator where a sequestration project is impacted by a natural disturbance, where there is a reversal of sequestration due to the conduct of a person other than the proponent, or where the proponent ceases to exist. More specific notifications may be required through the applicable method for a project, such as in the 2021 soil carbon method, where the proponent must notify the regulator following a change to the project's land management strategy. Notifications must be made to us within the timeframe specified in the legislation, with those timeframes differing between the notification requirements. Some requirements also stipulate evidence that must be provided with the notification, such as records relating to a disturbance event or updated versions of project documents. Once a notification is made, the regulator will consider the notification and determine the best course of action. We may simply note the details provided, may ask for further clarifying material, or in some cases may proceed with compliance actions. Proponents must be aware of the monitoring and notification requirements applicable to their project and ensure they're complying with those requirements. If a proponent continually fails to comply, that may affect their fit and proper person status under the scheme. The easiest way to let us know of a notifiable event is through our new Notify the Regulator form located on our online services platform. Once you've used the form to submit a notification, we'll consider it and advise if any further action is required. The form was published earlier this month, and we welcome feedback through the feedback button at the top of the online services webpage. I'll turn now to relinquishment and natural disturbances. Also, if you have any questions so far, please make sure you pass them along through to us in the Q&A function. We're excited to hear from you and answer those questions a little later on. Relinquishment requirements are associated with the enforcement of permanence obligations and support the integrity of ACCUs issued to projects. Relinquishment is generally used where the carbon stock associated with issued ACCUs is no longer stored within the project area. The regulator may issue a notice to relinquish under circumstances prescribed by the CFI Act, these being where a proponent provided false and misleading information that materially influenced the number of ACCUs issued to a project, where a project is revoked, or in certain cases where the sequestration has been reversed. In the case of a reversal, the regulator may issue a notice to relinquish ACCUs where the reversal was due to the actions of the proponent and not due to a natural disturbance, or where the reversal is attributable to a natural disturbance or conduct engaged in by a person other than the proponent, and where the regulator is not satisfied that the proponent had taken reasonable steps to mitigate the effects of that disturbance or conduct. If a notice to relinquish is not complied with, the regulator may place a carbon maintenance obligation on areas of the project land. The carbon stock on land subject to a CMO must not drop below the level of carbon present on the land when the obligation was placed. Under both provisions for relinquishment relating to reversal of carbon stocks, the reversal must be a significant reversal. The thresholds for a significant reversal differ slightly between the two relinquishment provisions, and a condensed excerpt of the relevant sections in the CFI rule are displayed on screen. Notably, both provisions refer to the project area as opposed to the carbon estimation area when referring to areas of land. Proponents should carefully consider the size of their project area, as this may influence whether a reversal is considered a significant reversal. If a proponent is unsure whether a reversal, such as that caused by a natural disturbance, is a significant reversal, they can voluntarily notify us of the reversal event, and we may be able to provide further guidance as to the next steps that they should take. The term natural disturbance is specifically defined in the CFI Act as being any one of the 5 events shown on screen where that event could not reasonably be prevented by the project proponent. These events may affect the permanence of carbon sequestered in project, resulting in a reversal of the carbon stocks. While proponents have an obligation to ensure they've considered the risks that these type of disturbances can cause to their projects, we understand there's only so much planning that can be done to mitigate against the effects of a natural event such as a bushfire, and the relinquish provisions do provide some grace to proponents impacted by natural disturbances. Relinquishment may not be required where a project was impacted by a natural disturbance and where the proponent can demonstrate that they had taken reasonable steps to mitigate against the effect of that disturbance event. Ideally, mitigation against disturbance events would be both proactive and reactive. Thorough permanence planning and detailed records of management actions can help proponents evidence that they had taken those reasonable steps and reduce the likelihood of relinquishment being required for their project. I'll now run through a hypothetical where a plantings project is impacted by a bushfire and discuss the monitoring, notification, and relinquishment requirements that may apply. In this hypothetical, a 100-hectare environmental plantings project was impacted by a bushfire caused by a lightning strike. The fire, which occurred after the project had been issued ACCUs, impacted 10 hectares of carbon estimation area. The natural disturbance significantly impacted project trees and caused a reversal of the sequestered carbon. The method requires proponents to monitor the project to identify and record disturbance events. To meet that monitoring requirement, the proponents can use on-ground monitoring or remote sensing imagery. Proponents must also create and maintain records regarding fires that occur in carbon estimation areas, such as the date and location of the fire and the percentage of trees killed by that fire. In this example, the proponent is required to notify the regulator of the disturbance. This is because the fire impacted at least 5% of the project area and is then considered a significant reversal. The notification must be made to the regulator within 60 days of the proponent becoming aware that the disturbance had happened. In this scenario, the proponent promptly submitted a notification using the form available in online services and included the records that they'd held about the fire. In this instance, the proponent had also developed a comprehensive permanence plan and was implementing risk management activities, including creating and maintaining fire breaks and reducing fuel loads by chemically treating grassy weeds. The proponent was also able to respond to the fire with equipment located on site and intends to conduct infill planting in the affected area. Based on the provided evidence, the regulator was satisfied the proponent had taken reasonable mitigating steps and decided not to issue a notice to relinquish ACCUs. If the proponent didn't sufficiently address the risk of bushfire in their project plan or were not implementing the controls outlined in the plan, the the proponent may have been required to relinquish ACCUs. There are a number of resources available to help you delve into these concepts even further. We have detailed guidance on our website that elaborates on the key requirements for ACCU scheme projects. Also available on our website is the Environmental Plantings Permanence Plan template that I'd mentioned earlier. You can find the Notify the Regulator form on our online services platform, and you can always contact us over the phone or via email if you have any questions. I'll hand over now to my colleague, Shakir Rahman, to discuss the requirements and key considerations for projects that have concluded their crediting period, but not yet completed their permanence period. Over to you, Shakir.
Thank you, Gabriel, and good afternoon, everyone. My name is Shakir Rahman. I'm the manager of the Plantings and Plantation sections under the ACCU branch at the Clean Energy Regulator, and I'd like to echo the acknowledgement and the welcome of our two previous presenters. Now, in case you are unaware, we have recently published guidance on our website on post-crediting period obligations for sequestration projects. We'll post the link for that guidance on the chat. And this segment, I will be speaking briefly about some of the key aspects of this guidance, including the post-crediting period reporting obligations under the Carbon Farming Initiative Act and the ACCU scheme, and again, particularly for the sequestration projects. It is important to remember for sequestration projects that the obligation for managing a project and maintaining the sequestration that has been achieved through the project does not end at the end of the crediting period. It continues on until the end of the permanence period. So thinking about ongoing obligations, in this slide, I'll cover some of the ongoing obligations that you will need to be aware of following the end of your crediting period if you have a sequestration project. If you are a proponent of a sequestration project, your ongoing obligation will include regular reporting, monitoring, notification, and record-keeping requirements that apply even after the crediting period had finished. And as Gabriel mentioned, permanence obligation, of course, apply to sequestration projects throughout the chosen permanence period. Now, to determine what obligations apply to your project must follow the post-crediting period requirements set out by the project's method at the time the crediting period ends. Now, if the project's method has expired, been varied, or has been revoked, the method requirement will continue to apply to the project till the end of the permanence period. Now, thinking of some of the obligations, so there's regular reporting obligations that apply. Project proponents must submit offsets report at least every 5 years during the permanence period, and that is to verify carbon benefits achieved during the project's crediting period. I'll talk about this a bit more in detail in the next slide. And then the next one is the monitoring obligation. And what we mean by that is that there are detailed information on the activities undertaken to monitor and maintain the carbon stored by the project. So these activities can include any measures taken to prevent and manage reversal, for example. And as long as your project is registered this CER, you must also monitor as required by the chosen method. So the project your method is under, there's monitoring requirement under that method, and you must abide by those. And each method would typically specify what those monitoring requirements are. And finally, there's the notification requirement that applies to a project till the end of the permanence period. And it is important to remember that notification requirement will remain in effect again till the end of the permanence. It doesn't just stop at the end of the crediting period. So as I mentioned, we have published guidance on our website on the post-crediting obligation, and that website on that webpage you will find the timeframes that apply to different types of notifications as well. Moving on to reporting requirements, as I noted earlier, after the project's crediting period ends, proponents are still required to continue to submit reports at least once every 5 years until the end of the project's permanence period. And the reason we need this regular offsets report is to ensure that the projects continue to meet its permanent obligation to maintain the carbon sequestration benefits that have been achieved during the project's crediting period. So this goes towards supporting the credibility of the ACCU scheme. So it's very important that you do so. Now, the ACCU scheme legislative framework, including your project's method, will provide specific guidelines on what information to include in this offsets report. And these reports include several key elements to ensure that ongoing compliance with permanence obligations are met. But typically, these reports will include a summary of the project, including eligible activities, location, and applicable method. There's monitoring and maintenance activities, which are detailed information on the activities undertaken to monitor and maintain the carbon stored by the project, and can also include measures taken to prevent and manage reversal events as mentioned in the previous, as Gabrielle has mentioned in her presentation. Then there's reversal events. If that occurs during the permanence obligation period, you must document that and include the nature of the event and the amount of carbon that has been released through that reversal event and the steps that you have taken to address the issue as well. And finally, there's compliance with permanence plan, which you have to provide evidence that the project is adhering to the permanence plan submitted during the creating period. So information could include updates on any changes to the plan and how these changes are being implemented. This can also include any additional documents required by specific method used by the used for the project, and it can include things like map, geospatial data, etc. Now, I would like to note that we are considering developing an offsets report template form in online services to use for projects reporting during the post-grading period. The aim is to simplify and sort of streamline this process as much as possible. So look out for that. Okay, now there is a useful provision in our legislation that applies to most sequestration methods, which would allow you to stop reporting on your sequestration project when it has reached its maximum carbon sequestration capacity. Now, what the maximum carbon sequestration capacity is, it is the full amount of carbon that can be stored in the relevant vegetation under the method by conducting project activities. Now, the rules are slightly different if you have a savanna sequestration project or a soil carbon project. For those projects, you must continue reporting for the duration of the permanence period. So this applies as long as the project is registered with us, and even if it has reached maximum carbon sequestration capacity, you'll still have to continue to report every 5 years. Now, for those who can apply to report reporting early, there is a PDF form located on the AccuScheme website under the post-grading obligation webpage. And as part of that form, you will need to provide multiple sources of evidence to show that your project has reached maximum carbon sequestration capacity. This evidence should be informed by the project's current carbon stock calculation and include things like the modeled growth curve for your project, if relevant. But it's important to note that you have to provide evidence that is supported by statement of an independent expert advice on how the project has reached maximum carbon sequestration capacity, and that can include their on-ground assessment of the project. You would also need to provide explanation of how you will manage any risk of carbon sequestration reversal during the remainder of your project's permanence period as well. Now, it is important to note that even if you are permitted to stop reporting, the monitoring, notification, and record-keeping requirements of the method will continue to apply to your project. Moving on to record-keeping, just quickly, you are required to retain records for 7 years after making the record to do with the carbon project. This allows you to comply with the regulators' requirements and support future potential audits as well. So you must meet the general record-keeping requirement of the CFI Act and the rule, of course, but also there can be certain requirements within the method under which your project sits. So you'll need to be aware of those record-keeping requirements as well. And again, on our post-crediting reporting obligation webpage, it displays a list of record-keeping requirements. So I suggest you check that out. Okay, so third-party obligations, we get questions about this every now and then, so we thought we'd cover that here. So if you are an agent or carbon service provider acting as a project proponent on behalf of the landholder, or if you are the project proponent but not the landholder, you must ensure that the landholder is aware of and agrees to the obligations during the project and the project's permanence period. So that can be done, for example, through a third-party contract, of course, covering how these obligations are managed and how the landholders should maintain the carbon stores. We, as a regulator, don't get involved in third-party contracts between landholders and project proponents. Our legal relationship is with the project proponent who is responsible for carrying out the project and meeting all the legal obligations, including during the permanence period. It is the project proponent's responsibility to ensure that post-grading period obligations are met. And you should remember that if you're a project proponent, failure to meet these requirements may result in a civil penalty order being made against you as a project proponent. Now, as the project reaches the end of its crediting period and through the remainder of the permanence period, we do encourage you to have regular conversation with the landholder on their obligations to maintain the carbon stored in the project area. And finally, on the last point I wanted to make is that our enforcement powers apply for the duration of the project's permanent period as well. It doesn't stop at the end of the trading period, and we will use them in cases when non-compliance has occurred. As we usually do, we use remote sensing and intelligence from other sources as part of our continuous monitoring of sequestration projects, and that again will continue throughout the project's permanent period. And if you do detect that a significant reversal has occurred in your project area, or there is concern with level of carbon stores, we may issue an audit as well to assess the carbon stores. So that's everything I wanted to cover, and now we'll move to the next section of the webinar, and I'll pass on to Rizwan and Lisa. Thank you.
Thank you, Shakir. Good afternoon, everyone. I'm Rizwan Akhund, Acting General Counsel of the CER, and I'm joined today by Alyssa Sealtew, who is a legal officer of the CER. Today, Alyssa and I will be going through some of the notable considerations when selling or buying a property with an AccuScheme project on the land, and in the next segment, estate management. For the first part of this segment, we'll run through considerations when selling or buying all or part of a property, transferring the project, the treatment of ACCUs and carbon abatement contracts, assuming that the seller is the project proponent. Then we will consider the relationship if a carbon service provider is the project proponent. AccuScheme projects are not necessarily noted on the land's title. Land may have a sequestration project running on it with potential permanence obligations. If you are thinking about buying a property, it is important to check the AccuScheme project register to confirm whether there is a project being run on the land. You can do this by using the downloadable version as Excel or CSV raw data of the project register. This register lists the land titles over which AccuScheme projects are registered. If there is a project on the land as buyer, there are various considerations to inform whether to buy the project. First, does the project cover all or part of the sale land? 2, what the type of sequestration project is on the land. 3, what permanence obligations apply and what are the costs of complying with them, including to discontinue the project, and what is the permanence period. 4, how much of the crediting period has already run. 5, how many ACCUs have been issued and are projected to be issued. 6, is there a carbon maintenance obligation on the land? Other factors to consider are 7, have you consulted with traditional owners where native title has been claimed or declared to exist over the land? 8, do you have the expertise in-house to run the project, or do you need to source that externally? 9, what are the costs of running the project, namely the costs of complying with auditing, record keeping, reporting, monitoring, and notification obligations? 10, does the seller have existing contracts to sell ACCUs, such as to the CER or to third parties, and are they relying on the project to fulfill those contracts? If so, how will those obligations be treated if the project is sold? 11, carrying out due diligence on the conduct of the project by the seller. And 12, if agreement is reached to take over the project, how should the transfer be timed? These are some of the important considerations. There may be more depending on the project and the property.
The considerations change depending on whether the sale includes the land and the project or the land only. We'll start with some important considerations that apply when the sale includes both the land and the project. From the seller's perspective, keep in mind that you have ongoing record keeping, reporting, auditing, monitoring, and notification obligations under the project until the CER has approved the project transfer.
From the buyer's perspective, if you are looking to take over the land and the project, the sale agreement should include the transfer of 1, the project, 2, the assets and information needed to run the project. On that point, the CER doesn't have the power to give historical information to a buyer even after settlement has occurred. So it's important as the buyer to get some sort of access and use right to that information if you need it to run the project. 3, the legal right to conduct the project. Our first presentation in this Be Accurate series was on legal right. So if you missed out, a recording is available on our YouTube channel.
In contrast, if the sale covers the land only, such that the seller will continue running the project after the sale is completed, from the seller's perspective, you will need an agreement which allows you to retain all things needed to have the legal right to conduct the project. This could include a lease or license over the land and equipment needed to run the project. You'll also need to agree with the buyer on arrangements about management of permanence obligations, such as arrangements that will apply in the event of reversal of credited sequestration. If you've tuned in to the start of the session, Gabrielle ran through permanence obligations in more detail.
From the buyer's perspective, you will need to grant the seller ongoing legal right to conduct the project on your land post-completion. You will also need to agree with the seller on arrangements about managing permanence obligations. There are extra factors to consider if the sale includes only part of a project area. There are 6 possible post-completion options for continuing the project if the sale includes only part of a project's area. As you can see on the slide, options 1 and 2 are either the seller or the buyer runs the project on the entire project area. For option 1, see the land-only section of the earlier slide. For option 2, the buyer will need to acquire the legal right over the seller's portion and assets and information, including historical records, needed to run the project. In option 3, the seller and buyer become co-proponents for the project on the entire project area. Each party will need to acquire legal right over the other party's land portion, and the buyer will also need to acquire assets and information. Option 4 is the seller and buyer run separate projects on their own portions of the project area. It will involve project restructure, and the buyer will need to acquire assets and information needed to run the project. Options 5 and 6 are converse, and either the seller or the buyer runs the project on their own portion of the project area, and the other party's portion of the project area exits the scheme. Both these options require ACCUs to be handed back if ACCUs have been issued for the part of the project area leaving the scheme. Options 4 to 6 depend on the method being enforced if ACCUs have been issued for land that will no longer continue as part of the project. A project area consists of carbon estimation areas, or CEAs for short. CEAs are areas where carbon is stored in vegetation or soil, and that sequestration is measured and reported on. A method may prevent a CEA from being split. If that is the case, and the CEA straddles land being sold and land not being sold, as shown by the yellow CEA in the diagram, you will either need to obtain legal right from the other party to continue running the project over the part of the CEA not included in your property post-completion, or remove the CEA from the scheme if the method is still current.
So how do we go about transferring the project? The process is a proponent variation. The first stage is for the buyer to assess if they'll be eligible to be a proponent. The proponent must be 1, responsible for carrying out the project, and 2, have a legal right to carry out the project. The buyer must also pass the fit and proper person tests. You can visit our website for guidance on what it means to be a fit and proper person in the ACCU scheme. If you think you meet the eligibility criteria, the seller should submit the Vary Proponent form. Our team aims to assess the application within 90 days. When processing the application, the CER will notify the registered native title body corporate if it has an eligible interest in the land. If the variation is granted, the buyer can submit offsets reports and apply for ACCUs for reporting periods ending after the transfer date. If the proponent variation will change the project proponent, The variation can be backdated to take effect from the date the outgoing proponent's legal right to conduct the project ceased.
ACCUs are earned for abatement achieved over a reporting period. As a golden rule, entitlement to apply for ACCUs sits with the person who is the proponent and on the project declaration immediately before the end of the reporting period.
While the seller is the proponent, they can change the end date of a reporting period as long as it's within 5 years of the start date of the reporting period. This means that the parties can negotiate whether the reporting period will end before or after settlement. If the reporting period ends before settlement, and importantly, before proponent variation, the seller can apply for ACCUs.
Conversely, the buyer can apply for ACCUs if the reporting period ends after settlement and the proponent variation. The parties can privately negotiate a redistribution of ACCUs which are tied to their respective periods of ownership of the project.
The project may also have related fixed carbon abatement contracts, or contracts for short. Fixed delivery contracts are contracts which the government entered into with proponents from 2014 to 2020, where the government agreed to periodically buy ACCUs for a fixed price, and the seller under the contract has an obligation to deliver an agreed number of ACCUs on agreed dates. If you as the seller are also a party to a fixed delivery contract, you'll need to decide whether to novate the contract to the buyer or keep the contract and source the ACCUs from other projects or the market to fulfill the contract obligations. An important obligation under the contract is to keep the ACCU sale price confidential. So if you're considering transferring the contract, please reach out to our carbon abatement contract team about signing an NDA so you can lawfully disclose the sale price to the buyer.
If novation is on the table, as a buyer, you'll need to assess if you can meet contract obligations. Then, if the parties decide to go ahead with the transfer, the seller, buyer, and the CER will need to sign a novation deed to carry out that transfer.
The actions required change if the project on the sale land is run by a carbon service provider. Carbon service providers are organisations which develop and manage carbon abatement projects. There will typically be an agreement between a landholder and a carbon service provider which sets out the provider's legal right to run the project on the land. If post-completion, the carbon service provider will continue as the project proponent, the carbon service provider would need to negotiate with the seller and the buyer to transfer the legal right agreement or enter into a new legal right agreement with the buyer. The buyer should nevertheless independently understand the permanence obligations relating to maintaining carbon stores on the land.
The next segment is estate management. This segment will run through general considerations where the project proponent is an individual and their estate includes an ACCU scheme project.
Estate management is complex and laws vary across each state and territory. If you're named as an executor in a will, we suggest you consult a wills and estate lawyer for guidance on administering an estate. Importantly, a grant of probate provides clear evidence of an executor's authority to the CER. When probate is granted, we can give you information about the project and the executor can generally take certain actions, which we'll go into more detail in a few slides. The executor must notify the CER of the proponent's passing within 90 days and the new project nominee if the project has multiple proponents. Please also keep us updated if there are any delays in getting a grant of probate that will impact the ACCU project. Notifications can be made before probate is granted, and the executor must also notify the CER of the new proponent if the project is sold.
So what happens to the project? Generally, the project becomes an estate asset. Once probate is granted, the executor will administer the will. The project could, as required by the will, get distributed to the beneficiaries or sold. We won't go into the details on the sale process since we've just covered that. Although the will may say how the project should be distributed or sold, the CER will still need to assess the project variation. The executor may apply to become the proponent before the assets are distributed or sold. After the distribution or sale happens, the beneficiary or purchaser can apply to become the proponent. The steps are the same as set out in our buying or selling segment. When assessing the variation request, our team will ask the executor for the grant of probate and may ask for a copy of the will. So we suggest attaching these documents to the form. An executor might choose not to become the project proponent or may not pass the fit and proper person test. So what can they do without being the proponent? If probate is granted, the executor can apply to transfer accused from the deceased Andrew account, apply for accused for reporting periods that ended before the deceased passed away to be issued to the deceased person's Andrew account. We'll get into the details on timing in the next slide. Perform project activities, submit offset reports to meet our reporting obligations. These actions are taken by the executor only and not by a beneficiary or a purchaser.
The table on the screen sets out generally what happens to accused. Remember the golden rule. Entitlement to apply for accused lies with the person who is the proponent and on the project declaration immediately before the end of the reporting period. Starting first with the accused in the deceased person's ANRO account. To hold those accused, the executor must first apply to open an ANRO account and meet the account opening requirements. Once probate is granted, the executor can apply to the CER to transfer the accused from the deceased person's account to the executor's account. Next, in row 2, if probate is granted, an executor can apply to the CER for accused for a reporting period that ended before the deceased passed. The accused would be issued to the deceased's ANRU account, as they were named as the proponent on the project declaration at the end of the reporting period. The executor could then apply to transfer the accused from the deceased person's account to the executor's account, similar to row 1. Going to row 3, if probate is granted, the executor may apply for accused for any reporting period ending after the deceased person passed, but before the assets are distributed. However, if the executor does not become noted as the proponent on the project declaration before the relevant reporting period ended, noting that once probate is granted, the executor can, by making an application, ask to be noted as proponent on the declaration on any date after the death, they cannot apply for accused for the reporting period, even if probate is granted. This may mean that the project loses eligibility for those accused. However, if the assets are distributed and the beneficiary or purchaser becomes noted on the project declaration as the proponent in any reporting period ending after the deceased passed, and that notation remains on the declaration at the end of the reporting period, the beneficiary or purchaser can apply for accused for that reporting period. This is shown in row 4. The executor will no longer be entitled to apply for accused for that reporting period, as they would not have been the proponent noted on the declaration immediately before the reporting period ended. Different rules which affect timing apply in different jurisdictions, particularly where probate is granted in the ACT. There are some additional considerations. This deceased person may have also been a seller under a carbon abatement contract. After the seller passes away, the contract continues and the executor steps in to meet the obligations under the contract. The executor will need to assess whether to keep or novate the contract according to the will. If the contract will be novated, please engage with our carbon abatement contract team for next steps. If estate land has a project run by a carbon service provider, check the contract with the carbon service provider to understand your contractual obligations. The contract would typically involve obligations to maintain carbon stores during the permanence period.
If we want you to take anything away from this segment, Remember that this is a complex area, so please seek legal advice and engage with our team. Our team understands that this period can be a difficult one for the deceased person's family, so we try to be flexible and help you where possible. It's good to reach out and keep us updated.
Okay, thank you, everyone. That concludes the presentation component of our webinar today. And again, just thank you to all our presenters for sharing their knowledge. Hopefully you found that useful. We will be posting a recording of the session on our YouTube channel. You'll also receive a short post-webinar survey by email, so please take the time to tell us what you thought and the topics that you would like covered in future webinars. And hopefully there'll be a few more hosted later this year, so please keep an eye out for details on our website. So again, thanks very much for your attendance and see you next time. Thank you.